of the Supreme Court today launching the e-filing registry, which is already ongoing, and we shall just take you down there to the tent momentarily to show you what is really happening right now. We do have also our panelists here that we'll be talking to in light of this new development. This is in streamlining the digitalization of the judiciary, which began 5 years ago, and of course today is an epitome of it. We can see now the Nairobi courts also are going to have this particular aspect of the entire streamlining of digitization. So it begins with the e-filing registry. Just to show you what I do have here also is a beautiful scenery at the Supreme Court, and of course you can see, as you saw earlier also, we have the social distancing being observed here at the tent as well. This will be presided over by the president of the judiciary. This is Justice Maraga, much later at 11 o'clock on the nose. In the meantime, we shall be also discussing with our panelists, and I want to introduce our panelists here that are with me. We have with us right immediate left here, this is Kevin Mbogo, who's an advocate of the High Court. We do have with us as well Steve Ogola. Steve Ogola is an advocate of the High Court as well. Also Stephen Ikelang. Stephen Ikelang is acting director of ICT at the Judiciary, and so we're going to broach this particular subject. I know many of you want to really understand how this will work. Many nuances to it, many challenges to it, and of course, immediate today, we know that the entire system will be electronic. Let's just begin with you, Steve, because there's a level of awareness that this system presupposes that is in the public. From your own assessment, do you think there has been a robust, maybe, should I say, civic education as far as the e-filing system is concerned? Maybe we can just begin from the e-filing system. What is it?
I think thank you, Debal. What is important to underscore, first of all, that the global or overall objective of transitioning from the manual filing to e-filing is to broaden access to justice. So we have to understand that, first and foremost. Number two, there's been a lot of stakeholder involvement, especially with the advocates who are form the majority of court users. There's been limited involvement of the public. I think there's still going to be opportunity for public to engage with the process, because this system that is being launched today should be accessed by advocates, institutions, as well as individuals. So yes, engagement has been going on, but it needs to be deepened, because the overall objective is to broaden access to justice, to reduce the cost of accessing justice, to cut on time, the waiting time, and to improve accountability and tracking of your case. So in the overall, if it works well, yes, it's a good thing.
It's a good thing. We had also Dr. Martin Deiche, who is the Vice Chair of Judicial Service Commission, and she was saying that, quote unquote, current global discussions intimate that COVID-19 is here to stay. We have no option but to get technology right. Do you think this has prompted also the COVID-19 pandemic that we do have with us right now has really prompted this particular also rollout currently? Kevin?
Okay, I think in my view is that the COVID-19 pandemic has acted as a catalyst. This was eminently coming. We know legal evolution, if I may call it, digitalization of the process, began way back in the 90s. We have history points that countries such as Austria started their e-electronic systems or electronizing the judiciary from 1999. And it is here with us. Technology is here to stay, and I can only say that the COVID-19 has acted as probably the first test and then a catalyst to this. Yes. In my own estimation, it is a good system to an extent. It promotes access to justice. It promotes digitalization generally, promotes accessibility. And as such, I think it's a good system.
It's a good system.
Yes.
Maybe we could now rope in Stephen, because we'll get into the nitty-gritty of it, of how it will work. But you can just give us a broad perspective of what e-filing is from the ICT, perspective. How do I, maybe as the common mwananchi, use this particular system? How is the payment? How also do I rope in my lawyer? Break it down for us briefly.
Okay. Thank you. The system is open for the public, advocates, organizations, and state agencies. So they can easily create accounts in the system so that they start the filing process. So once you have an account with the system, you will be required to provide your details, ID number, email address,
Yes.
phone numbers. So once you have that, you can now proceed filing. So the first step is the submission of your case details. Once you provide your case details, you also indicate the documents that you intend to upload. Once you upload the documents, it will assess the court fees that you need to pay and present to you with payment options, M-Pesa and our banks. Once you pay, you automatically get your acknowledgement and the case number together with a stamped document from the court.
Yes.
So after that, you have put the details of your defendants or accused or whoever. It will also be communicated to the other party if you have the contacts. Once that is done, you can also do electronic service. So once the court approves you have a case number, the documents have been accepted, you can now do e-service. So e-service will require an email or a phone number for the purpose of notifying the other party that there is a case against them. So they will be sent a link on which they will do the same thing, create an account, log in and file their response. And once they file the response, every party in that case will be notified that the response has been filed and the case is now can proceed to the next step. So that will follow various steps in court, hearings, mentions, and whatever other scheduled activities that are there in court will now even be continuously being updated in the system, so that everybody, the correspondence and any exchange of information is entirely done in the system.
Right,
So,
thank you.
Yeah, that's an overview.
Right, that's the overview of it. We'll come also to maybe the challenges on the system as well that maybe
Yes.
may arise and how we can navigate through those challenges as well. But let's come to Steve and look at the swings and roundabouts about this particular project as it is right now. What are some of the quick wins that you think this project will roll out? I know maybe the delay of cases, the backlog that we've been having because of, having bulky documents and stuff like that, and people cannot really roll out justice expeditiously. From your assessment.
Yeah, I think it's important to clarify
Yes.
that this electronic case management system being launched today is not a response to the COVID-19 pandemic. It has been an ongoing conversation and technological advancement. But during the COVID-19 pandemic, we saw what we call electronic case filing practice procedures and guidelines, which was supposed to make filing easier. But what we will have, to respond to your question, when this system is fully automated and functional, one of the quick wins that we'll have is that it will expand access to justice, because every Kenyan can track the progress of their case through their lawyers or individually if they filed their case individually. Number two, it will reduce the cost. Remember, Kenyans have to travel. If you have a case in Nairobi, you have to travel from Mandera, from Kirinyaga, from Kisumu to Camp Nairobi to attend a mention and then waste money, and sometimes you find that the court is not sitting. So in this system, you will know when the court is sitting, you will know the progress of the case and you will then get to save time and money. Number three, there's a bit of accountability involved in it, because usually, as you said, you will, for the case to progress the next stage, or for the filing to progress the next stage, the other parties must also respond to the case by filing the necessary documents. If a party refuses to file the documents or delays,
Yes.
you will know where the delay is happening, and then it's easier to hold that person to account.
Yes.
So there's the question of cost, there's the question of time, there's the question of accountability. Remember, previously, files used to get lost. So this will correct that. You can no longer say that my file is lost in the archives or in the registry.
Yes.
So that has been clarified, because now all of these files will be e-files, and it is easy to track because every case has a case number, and then you can see where the progress is. So generally, we can expect a more inclusive and broadened access to justice if the system is if the system works in the manner in which it has been intended.
All right. But is the system entirely, designed to? Because looking at it, it seems like it is entirely designed to solve the civil cases and not the criminal cases as it is right now. And looking at all these, courts that we have, the anti-corruption code, the commercial and taxation, judicial review, constitutional and human rights, criminal, family and civil, how will it play out, in trying to, expedite cases in all these courts?
There's a genuine concern that the system being rolled here largely responds to civil cases and not necessarily criminal cases or anti-corruption cases that must be initiated by the state through the Office of the Director of Public Prosecution.
Yes.
If you look at the dashboard, the system for uploading the case, it's supposed to be initiated by individuals or the law firms,
Yes.
or state institutions or organizations that want to file cases. But what happens if it is a criminal case? When the DPP intends to prosecute someone, there are serious legal, procedural and constitutional concerns that will emerge. And I hope some of them will become clear as we continue. For instance, if you want to charge someone, the DPP must file that charge sheet electronically. But how do you get the accused person to access that portal? Is it before taking plea or after they've taken plea?
Yes.
And at what point do they involve their lawyers? Because you see, as it is now in the manual system, if a lawyer gets information that a client is going to be charged, they can even challenge the propriety of the charge sheet, because they take instructions ordinarily by the client walking in the office or asking them to come to the cell. But right now, a lawyer cannot access that system until you've been given the login credentials. At what point do you get the login credentials? What I'm saying in short is, this system needs to be developed further to interact with the criminal justice system, not just the civil justice system. So there's a bit of gap there. Maybe the ICT person can give us more clarity on what they intend to do to bridge the gap on the state side in anti-corruption cases and also in the criminal cases.
Look, Kevin, let's just come to you also, and the issue of, we eagerly wait to hear from the CJ. Will it be entirely going electronic today, or it can be integrated or complemented also by the manual system? And also Stephen will add up onto it. But from your own assessment, do you foresee us going purely electronic?
Well, going purely electronic maybe will be, let me say, a disaster. A disaster in the sense that we have,
I think I have some technical challenges with the mic a bit. Is it off? Let me just see. A long press it. It's back. Good. Yeah, you're good to go.
We have issues, a disaster in the sense that the whole country is not techno-savvy. For instance, we have parts of the country who do not understand what an internet connection is.
Yes.
We have parts of the country that hardly have any access to roads, leave alone the Wi-Fi we are talking about. The system, as we understand it, should be complementary in a way, as much as it should be a work, an ongoing progress. There should be a complementary system in the way of manual. For instance, we know that internet challenges are here and there. The system may be down at one point or the other. How do we cure that? Remember, the legal practice is we have laws and regulations governing the practice. It is not an issue of I file. There is the concept of limitation of time. How do we cure that? Where a system is down, it is the last day of filing for a specific matter. How is this party able to challenge that? How is this party able to go through it without necessarily interfering with the authenticity of the matter as may belong? So I think we should have a complementary system in place, and I would say in some instances we may have really to still go on with the manual.
Yes. All right. Maybe I also shall drop it, Stephen, on this, because I think this is right in the middle of what you're really doing as it is right now. Do you think the electronic or the manual system also should be integrated on this? Because looking at the electronic case management practice direction that we had the Gazette notice, just to give a snippet of it, they said that electronic filing, a section of it, is permitted at all times when the electronic filing system is available, and where the electronic filing system is unavailable at the time the user attempts to file a document, the user shall make reasonable effort to file a document as soon as the electronic filing system becomes available. Where do we have also maybe cases where timelines are there? They are time bound, like the certificate of urgency that you need to maybe have actually file this by 12 o'clock in the day, and we have glitches in the system. What happens?
Okay, what we have proposed and what will be in place is that, like the president has indicated, if you have challenges in filing on the system, we also have alternative communication channels like email to report that you are unable to file this matter, for us to take actions, because that report will be very important for us to prove that you've actually attempted to file and you are unable to file. So that report will give an exemption to that party so that we address that issue separately. But all in all, after we receive that report, we will give an exemption so that this matter can be filed either through an email is sent, but it will still have to go back to the electronic filing system for the due process. Because that is the avenue that we have to give in terms of anybody who has challenged to file. Yes.
Right. So I need just to make an interposition here a bit. We go back to the tent and see what is happening there. Kevin, Steve and Stephen, just hold on. We shall be coming back to you once I get the direction to do so. But for now, we want just to see what is transpiring inside the tent. Remember, you're watching the official launch of the e-filing registry. This is for the Nairobi courts, which is happening today. And of course, at 11 o'clock on the nose, which is about 15 minutes from now, we shall be seeing also the CJ launching that particular, of course, digitization of the e-filing system. So let me take you in and just continue with the proceeding instead so that we can get a snippet of what is really happening right now.
Who have steered and continue to steer the e-filing subcommittee, the Honorable Justice Tuyot for steering the audio recording and transcription committee, Justice Jackie Kamau for her work in steering a migration plan from the manual to the digital and the sensitization, and Honorable Mange for steering the tracking case system, and Mr. Ikeleng and his entire team in the directorate. I also want to acknowledge and thank the Honorable Mr. Justice Joel Goge and Dr. Kerez, who have been our constant resource persons at the various workshops that we have had with a view to developing these solutions. And as I may not have another chance publicly to thank the Honorable Chief Justice, because we are constantly these days reminded that his birthday is approaching, I want to thank you, Lord Chief Justice, for having given me the privilege of serving in this committee. Thank you all very much.
Thank you very much, Judge Gatembo, for your remarks, and we appreciate what you have done for the institution. Our next speaker is Charles Mutinda, the Deputy Chief State Counsel, representing the Attorney General. I don't know if he's here yet. Okay, he is not yet with us here. May I also acknowledge the presence of the Permanent Secretary, Ministry of ICT, Mr. Jerome Ocheng. Welcome, PS. And as we wait for Mr. Mutinda to join us, it's now my pleasure to ask the President, Law Society of Kenya, Nelson Harvey, to address us. Welcome, Mr. Harvey.
My Lord the Chief Justice, my Lady the Deputy Chief Justice, members of the bar, members of the bench, members of the executive and members of the legislature, if there are any here, and members of the diplomatic corps. Good morning. May I please have my counsel upstanding so that I just acknowledge you before we proceed. With me here, together with Nairobi branch, be upstanding. With me here are my council members, starting from Nairobi branch, the chairperson, Mr. Eric Theory, the vice chairperson, Madam Helen Namesi, a upcountry representative for the main office, Madam Esther Ngawa, Nairobi representative to the council, Madam Faith Odhiambo, Nairobi representative to the National Council, Madam Eileen Aluso Ingati, Nairobi representative to the main council, Madam Caroline Mudeu, and my very able vice president from Alliance Girls, Madam Daudi Kamende. It was my expectation that my classmate Charles Mutinda will have spoken first, then I speak afterwards. It is a demonstration that Mwalimu Kairu Gatembo, that your students have grown of age. If Charles Mutinda, my classmate, will represent the Attorney General, then I don't know who I'll represent from this side, but I think I represent all of us here. It is said necessity is the mother of all invention. I don't know whether they will say fortuity is the father of all regression. My Lord Chief Justice, I remember on the 15th of March 2020, I was traveling from Eldoret. Then I was notified that an urgent meeting of the NCAJ had been called. And I didn't make it in time, but what transpired then was the scaling down of the operations of the court. It is the COVID pandemic that caused the scaling down of the court. And may I take this opportunity to thank all the players who are behind this project for ensuring that we have innovated within the confines and the limitation of this pandemic. I do not know whether I would have been able to do this were it not for the pandemic, because there have been numerous attempts to digitize the court process, but all have not succeeded. Yesterday night, as I was drafting my speech, because I always draft my speech at night, and I don't have a printer at night, it came to my mind that I must acknowledge many who have distinguished themselves in the era of e-digitization in court. I will start with my civil procedure teacher, Kairu Gatembo. I remember from the first time he sat as a judge of the Court of Appeal, I did not see him with a pen and a piece of paper. He came to court with a MacBook. May I also acknowledge several judges of the High Court. I will start with Honorable Justice Mary Kasango, who is very industrious in the management of our course list. Often we see over 20 matters on our course list, and I can tell you without any fear of contradiction, she clears them effectively. May I also acknowledge Justice Francis Tuyot, who has ably managed the commercial division, and in that regard, may I also acknowledge Justice David Majanja. We have experienced several teething problems insofar as transforming from the analog to the digital platform in court is concerned. Often you hear of this common phrase, "My lady, can you hear me? Can you see me?" Yesterday, somebody posted on Twitter that he had been waiting in the virtual court for almost 4 hours. And when his time came for the client to take play, the link from the police station just got lost. And his client had been waiting in the cells for 4 days. A signal was made from the police station that they'd lost power. A story is also told of a judgment that was delivered when none of the parties had been notified of the delivery of the judgment. None of the parties attended. These, my friends, are some of the problems that we need to deal with. And we must deal with them because we're not the first ones to innovate. Alexander Fleming took the opportunity of coming up with penicillin when we didn't have an antibiotic to take care of medical problems. Graham Bell came up with the telephone when there was need for us to communicate very well. Valentino Tereshkova went to space when there was need for man to discover what is in the outer space. Lord James Richard Atkin came up with the duty of care principle when there was need for us to define how to relate with each other in the society. My Lord, the Chief Justice, I don't know whether you are the father of fortuity or whether you are the mother of innovation, but I think this is a perfect opportunity for us to create for you an enduring legacy insofar as e-registry is concerned and so far as e-courtroom is concerned. As the Law Society, will be here to ensure that we develop this system so that it benefits everybody, members of the bar, members of the bench, and the entire public optimally. Often we will criticize you, often we'll compliment you. Take all this in stride, because it is our responsibility and obligation not only to protect the independence of the judiciary, but also to hold you accountable. No wonder, therefore, Mr. Justice Sam Okongo, a few weeks ago, when we were contemplating on how best to make this system work, I told you, you can see at the background of my office, it's more elegant than yours, and I don't need to come to your court. My Lord took profound umbrage, but I think that was an indicator that we needed to do the correct thing. Because the opulence of this building, perhaps, is the reason as to why we have never innovated before. And the need for us to work from the locality of where we may be found at whatever particular point in time could be the reason as to why this noble project is being launched today. May I also take this opportunity to speak to the executive through the Cabinet Secretary, Adan Mohamed. Adan Mohamed, I will kindly request you to convey our request to the executive, and in particular to the President of the Republic of Kenya, to ensure that the judiciary is adequately funded so that this noble project is sustainable, so that this noble project benefits the members of the public, makes access to justice effective. At the same time, may I also make a plea that we come up with a bill which will ensure that this project is given a proper legal framework, because there is a possibility of e-registry and e-courtroom being abused. And we've seen it in the recent past, how the freedom created in the internet space has been abused. Judges, advocates have been the subject of castigation, attack, and vilification through the social media. I'm sure soon enough judgments will start appearing in the social network, which have been doctored because of the limitations that we have when we have to conduct the business of the court through a judicial platform. It is therefore incumbent upon us to put in place a proper framework in law to ensure that this system is not abused. My Lord Chief Justice, it looks like everybody is wishing you happy birthday in advance. I may not get you an opportunity to congratulate you for the service you've rendered to the Republic of Kenya for the entire period of time that you have been the Chief Justice. At the beginning, I was one of your biggest supporters, I must acknowledge. At one point in time, I was also one of your greatest critics. But at this point in time, my Lord Chief Justice, may I confirm to you that the demands of the moment require that we work in unison. I can therefore guarantee you the unwavering support of members of the bar in ensuring that the remaining term of your service to the judiciary is conducive. In the event that there will be need for us to speak, we will speak. In the event that there will be need for us to act, we will act. Because it must always be remembered that one is first an advocate of the High Court of Kenya before he becomes a magistrate. One is always an advocate of the High Court of Kenya before he becomes a judge. It is therefore our responsibility, members of the bar, to ensure that this institution of the judiciary is protected. As Lord Denning said, it is not upon them to speak, because if they were to speak, they are likely to be misinterpreted. But you and I have the right to speak, and we must speak. And it's for this reason, therefore, that we'll continue speaking, indicating to you the areas that require change, the areas that have been perfected, insofar as e-filing and e-court is concerned. Today marks 100 days since I assumed office. It is therefore a day that is special to me. It is therefore a day that is special to the bar, and also to the bench, because I've been able to recruit a few members of the bench into the brave new bar. In the Court of Appeal, I'm told Justice Moinoti is brave. Welcome to the brave new bar, my lord. Esther Ngawa, bring the books. In the Court of Appeal also, I must acknowledge that Justice President William Ouko has been recruited to the brave new bar. Don't feel isolated. The brave new bar is available to everybody. My lord, the brave new bar came into office on the 27th of February. We have documented those who participated in that exercise, and I would like to present to you this album before I exit the stage. My friend, my very good friend and senior, Mr. Nurdin Haji, the DPP is here. May I also acknowledge the efforts that the Office of the Director of Public Prosecution has played in ensuring that the wheels of justice move seamlessly and effortlessly. Thank you, friends. Let's make this work. Mbarikiwe sana.
Thank you very much, Mr. Harvey, for those remarks. We appreciate the support we have received from the Law Society of Kenya. As at yesterday, 5 o'clock, 197 advocates had filed cases through the e-filing platform, which is a great thing, and we hope that from today, everybody will be on board. Thank you very much. It's now my pleasure to ask the Director of Public Prosecutions, Mr. Nurdin Haji, to address us. Mr. Haji, please.
My Lord, the Honorable Chief Justice and President of the Supreme Court of Kenya, Honorable Justice David Maraga, my Lady Honorable Deputy Chief Justice, Lady Justice Philomena Beta Mwilu, Honorable Justice of the Supreme Court, Honorable Adan Mohammed, the Cabinet Secretary, the Honorable Chief Registrar of the Judiciary, Honorable Anna Madi, His Excellency the Ambassador of the Netherlands, Honorable Judges and Magistrates, the President of the Law Society of Kenya, Mr. Nelson Harvey, PSICT, Jerome Ochieng, the Chief Executive EACC, Mr. Twalib Mbarak, distinguished guests, ladies and gentlemen, good morning. I think the LSK president disarmed me because I was going to stand and complain for having championed the needs of the judiciary. But I think at the end of it, he acknowledged our role as ODPP and has also been championing our cause as the Office of the Director of Public Prosecutions. Because indeed, through the criminal justice system, if we are not able to work seamlessly, and we are also not able or enabled, then the judiciary will also not be able to work efficiently. Thank you for acknowledging us. It is my great pleasure, my Lord, an honor to be part of this occasion as we witness the launch of the electronic filing system. ICT plays a key role in the administration of justice. The ODPP therefore welcomes this timely launch of the e-filing system for the courts in Nairobi. The outbreak of the COVID-19 pandemic in the country in mid-March hastened efforts to incorporate the use of ICT in service delivery to Kenyans. This has resulted into a more technologically driven system, which is the new norm in service delivery today globally. Indeed, the judiciary, the ODPP, and other court users within the criminal justice systems have been using ICT platforms to file, conduct hearings, deliver judgments and rulings in line with protocols issued by the Ministry of Health in ensuring social distancing. Although the pandemic has brought about the faster adoption of technology-driven court processes, we also recognize that the adoption of technology is part of the judiciary's digital strategy as enshrined in the Service Delivery Agenda 2017-2021, which is geared towards re-engineering the court processes through the adoption of ICT. The e-filing system by the judiciary will help increase and achieve higher levels of efficiency to all stakeholders. The process will save the time as court users will file their pleadings online as opposed to physically going to court premises. The benefits of e-filing cannot be overemphasized. It will lead to reduced chances of corruption, hopefully, and other related man-made challenges to the justice system. Of course, there will be other challenges as enumerated by President Harvey. This will enhance transparency and accountability, thereby building the public's trust in the entire justice system. Further, the automation and e-filing system will enable criminal justice actors to track court performances and files, resulting in faster case resolution, thereby reducing backlog. The judiciary's objective of enhancing efficiency through the use of technology is in tandem with the ODPP's strategic objectives and ICT framework, as encapsulated in our Strategic Plan 2016-2021 and the ODPP Excellence Charter. While the civil part has made strides, we at the criminal justice system are determined and have not been left behind either. To this end, ODPP has developed a case management and document tracking system to facilitate efficient and effective delivery of prosecution services. And in collaboration with the judiciary, we have managed to integrate the criminal case management system to enable a flawless filing process and sharing of court-related documents. The successful filing and integration was actually achieved last night after sleepless nights of our ICT teams. Through these systems, our office, that is the ODPP and the judiciary, will be able to file charge sheets, disclose witness statements, documentary evidence, and file application and submissions electronically, among others. It is further envisaged that the ODPP case management system will eventually be integrated with all the other criminal justice agencies to enhance access to justice. As part of the adoption of technology-driven solutions, there is need to ensure court proceedings are streamed through virtual platforms, such as video conferencing, to prevent overcrowding of courts and allow members of the public and interested parties to follow the proceedings. As I conclude, my Lord, I note that the custom and norms of legal professions may to an extent cause the legal fraternity to be slow in adopting technology. However, a time has come where we must all adjust to the demands of the recent times, become a student of change. It is the only thing that will remain constant. Considering today is your birthday, I'm not sure how old, my Lord, you are. You have really adopted change, and it's no excuse. Age is no excuse. That's what I wanted to emphasize. I urge all prosecution counsels, advocates, and all relevant stakeholders in the criminal justice system to be versatile and to take the collective responsibility to embrace and adapt technology. Finally, I would like to thank the Chief Justice, really, for steering the NCAJ in developing practice directions on electronic case management issued on 4th March 2020 to provide guidance for the integration of ICT in judicial proceedings. And I must emphasize that the Chief Justice really provided leadership, despite the fact that within the NCAJ, President Harvey was adamant that courts must be opened, and some of us were adamant that we were not ready to have the courts open. But eventually, I think, my Lord, you were able to steer it the right way, and we are here today to witness that. I would like to reiterate my office's commitment to integrating this system and making sure that it works, to also strengthen our partnership and improve the administration of criminal justice. Thank you, and God bless you all.
Thank you very much, DPP. Thank you so much. The office of the DPP is one that we find really, really responsive whenever we have any challenges in any court station. We thank you for that. We do not take it for granted. Thank you for making our work easy at the court stations. It's now my pleasure to invite Mr. Jerome Ocheng, PS, Ministry of ICT, Innovation and Youth Affairs. Mr. Ocheng will be speaking on behalf of the Cabinet Secretary, Mr. Joe Musheru, who was not able to join us this morning. Mr. Jerome, please.
Thank you very much. Thank you very much, Chief Registrar. To the Honorable Chief Justice David Maraga, Chief Justice and President of the Supreme Court, to the Honorable Lady Justice Philomena Mwilu, Deputy Chief Justice and Vice President of the Supreme Court, through the Honorable Eden Mohammed, Cabinet Secretary, to the Chief Registrar of the Judiciary, Honorable Anne Amadi, to Mr. Nuruddin Harji, Director of Public Prosecution, to Mr. Nelson Harvey, President of the Law Society of Kenya. All protocols observed. Ladies and gentlemen, good morning. I am glad to join you today to launch the electronic filing in the Nairobi courts. Let me start by first of all conveying the apologies from the Cabinet Secretary, Honorable Joe Musheru, who was to be present here today, but due to exigency of other duties, he was not able to be with us, but I'll read his speech. I wish to add my voice in congratulating the judiciary for the journey that you have walked so far and the visible gains made in automating the judicial processes and citizen engagement channels, a journey that has begun almost 10 years ago. Vision 2030, our blueprint for national development, places information, communication, and technology at the core of its achievement. ICTs underlies all processes, and a good ICT system would assure that the attainment of the development goals in the blueprint. All arms of the Kenyan government have committed to this blueprint and hence has embraced ICT as a key enabler in the creation of what we describe as a smart Kenya. As the Cabinet Secretary, whose docket focuses on innovation, technology, and youth, I must emphasize the role that technology plays in service delivery and transformation of government. Technology enables for transparent, efficient, and effective accomplishment of tasks. Technology also shortens distances and also speeds up routines. Disruption, leapfrogging, and transformation are all keywords that accompany the implementation and use of technology in day-to-day human interactions. Today, we stand at the center of a revolution in the judicial processes, and at the core of it lies technology. Ladies and gentlemen, Kenya has positioned itself as what we describe as the Silicon Savannah, and we would like to be the choice destination for ICT investments and growth in the region. As a government, we have taken major steps to enhance our attractiveness to investors, as well as harness the creativity and innovation from our citizens, especially from the youth. As we continue to make the much needed legal and policy changes that would assure our efforts yield fruits. I remember the President raising the issues about the legality, and that is an area that we are committed to working together towards ensuring that we have legal and policy changes that would ensure success. All arms of government must demonstrate diligence, transparency, and meaningful return on investment to our citizens. Digitization is at the core of all government processes. Projects such as e-Citizen, the Huduma number, iTax, IFMIS, the National Transport Management System, and the digitization of all registry are all geared towards driving transparency and accountability to Kenyans, and also to creating a trust ecosystem, and above all, better quality of life for all Kenyans. Ladies and gentlemen, in January 2017, the Judiciary launched the blueprint on sustaining judicial transformation. A service delivery agenda, that is 2017 to 2021. The blueprint lays great emphasis on use of ICTs to enhance service delivery. As part of the overall judiciary transformation project, the Ministry of ICT, Innovation and Youth Affairs partnered with the Judiciary on various initiatives that included connectivity, structured cabling, provision of devices, adoption of framework contracting of ICT, and use of government data centers. To emphasize on that, what we are simply saying is that as we run this application, the filing system, behind it is required a reliable, stable ICT infrastructure. And that is where our roles comes in. And we've been working very closely with the Judiciary to ensure that we have fiber cable running across all the courts, and also structured cabling that will be enhanced, together also with the delivery of equipment. So the issues of a stable infrastructure is very key to us, and we will work with the Judiciary to ensure that that is achieved, so that we don't have the cases of spending 20 minutes just to confirm whether you are hearing me or you are seeing me. And that is the solution we want to provide. The government has recognized the role that ICT will play in building the economy and also job creation. We are relying on the sector in building a knowledge-based economy that will shift the current industrial development path towards innovation, where creation, adoption, adaptation, and use of knowledge remain the key source of our economic growth. In 2016, the Government of Kenya, through the Ministry of ICT and in partnership with the academia, civil society, and the private sector, established what we call the Ajira Digital Program that would help to bridge the gap between skills, demand, and jobs. The program aims to introduce young people to digital and digitally enabled work and provide the tools, training, and mentorship needed for young people to work and earn an income with dignity. Last year, the ministry, through the Ajira Digital Program and the Judiciary, partnered on a project to digitize courtroom proceedings, and we've been working very closely with the Justice Gatembu's team in order to improve service delivery for the general public by increasing access to justice through the availability of digital platforms of court's record in the form of audio, video, and transcripts, whether offline or online. The Judicial Court Recording and Ajira Digital Platform project is an integrated end-to-end system that speeds up the production of court proceedings, and when fully implemented, will see close to 1,400 youth earn dignified income from transcriptions of court proceedings countrywide. There is strength in numbers, and this project has been made possible by key partners whom would like to acknowledge, that is the MasterCard Foundation, KEPSA, and the e-Mobilis. So as we launch the e-filing today, on the pipeline, the next step will be actually launching the digital recording of court proceedings, which is also another effort that we are doing towards digitization of our judiciary system. In conclusion, thank you. In conclusion, I wish to once again congratulate the judiciary for this key milestone, availing a platform for law firms, lawyers, and non-lawyers to initiate and complete the process of filing cases remotely, the process that will ease congestion in our courtrooms and also help in improving service delivery and efficiency across the board. I am encouraged and equally excited at the efforts made by the judiciary in driving their transformation agenda. Honorable Chief Justice, I would like to end by pledging the support of my office, the entire ministry, in helping you to reach your transformation goals, the impact of which will be significant to all Kenyans residents and also a great examples to the region and in Africa. So as we conclude, what we are saying is that as a ministry, we are committed and we are able and willing to work closely with the judiciary to ensure that these goals that we have set out to achieve are actually achieved. Thank you very much, and God bless you all.
Thank you very much, P.S. Ocheng. We appreciate the journey that you've walked with us in all these initiatives, and we are grateful for the commitment that you all, and the assurance that we can continue to leverage on the resources that you have. We do not take it for granted. Thank you so much. It's now my pleasure to ask the Cabinet Secretary, Ministry of East Africa Community and Regional Development Affairs, Honorable Aden Mohammed, to address us. CS, please.
Thank you very much, Madam Registrar, my Lord the Chief Justice, my Lady the Deputy Chief Justice, colleagues, ladies and gentlemen. One of the hobbies that I have developed in the last few months has been to see the shapes of the masks people are wearing. It has nothing to do with how expensive or cheap it is, but what damage it's doing to your ears. I am told one of the biggest innovation that is going to come out after COVID-19 is a technology that will put back our ears where they were before. In fact, I was just looking at the Chief Justice's one, and you may need a big operation. And so because this is very tight, if you don't mind, let me just remove it whilst I'm here. I'll make very brief remarks. First of all, to explain why I'm here. Number two, just share with you some of the reform programs that we're doing in the country and some of my own observations about the reforms that have happened in the judiciary in the last few years. I am running a program that is government-wide on behalf of the executive in improving the business environment for Kenya, making sure that Kenya becomes one of the most competitive places to do business and attract investments from the rest of the world into this country. That exercise is a globally benchmarked exercise that is run by the World Bank, and they do check countries' competitiveness by ranking them against one another to see how friendly country A is in terms of doing business and where their relative positioning is. In 2014, when we started this exercise, Kenya was ranked number 137th country out of 190 countries as, a place to do business that is competitive. So you can imagine how far down we were as a country about 6 years ago and how badly we were ranked vis-a-vis the rest of the world in our efforts to attract investments into our country. Today, we are ranked position number 56 out of 190. Our targets and the objective, the President's aim is to make sure that we're in the top 20 countries in the next 2 to 3 years in terms of attractiveness to do business. That goal is achievable. That goal is one that we are all focusing our eyes on. And this exercise that is benchmarked by World Bank across the world is made up of a number of components that make this ranking meaningful for the business community and for investors. And so because I have been leading this exercise on behalf of the entire government, the judiciary and all other arms of government, including Parliament, have been a very, very common place for me to visit on a regular basis to see what we can do and change. Now, let me just highlight some really big things that people may not recall, but that have made significant difference for us as a country in the journey towards making Kenya a much more friendly place to do business. Number one, in 2015, many of you may not recall this, we have launched a new Companies Act, replacing the 1948 Companies Act that was left here by the British. The old Companies Act was one that was geared towards supporting big businesses, looking after wealthy businesses, and very little focus on the smaller business. Today's Companies Act allows people to have one director, one shareholder. You don't need to have an AGM if your capital is below a certain amount. You don't need to have a company secretary. All geared towards supporting the small businesses that we have. We have a new Insolvency Act that is geared towards helping business to survive rather than what was there before, which was once businesses get into distress, they die immediately. We have waived a number of fees, whether it's NEMA, National Construction Authority, the Kenya Plant and Inspection Service, KEFIS. A whole raft of fees have been waived. And many of you will recall, now that we are in the judiciary zone, all commercial cases that are amounting to less than 1 million shillings, we don't have to have to pay filing fees. That has also been waived, amongst many other fees that will continue to be relooked at by the government to see how we can make it an easy place for us to do business. Today, approval of plans at the City Council today is chaired by a private sector person. That, in 2 weeks now, we can have plans for approval for developments approved, and we have hitches here and there occasionally, but it's a journey that we have started, a journey that we want to see make Kenya a really, really attractive place for investors to do business. And whenever I talk to investors, I get asked two fundamental questions, amongst many other things, but the two heavy ones are, if I want to come and do business in Kenya, and I step on the wrong foot of big people, would I get punished for that? And I say, okay, I'll go think about it, but I write it down. The second question they ask is, if I get into a commercial dispute, will I get fair justice and justice quickly? These are what lawyers and their clients always talk about, and this is what people are always complaining about. It is for that reason that judiciary becomes a very important plank of this business environment, because if you think about it today, the entire banking sector have more than 500 billion shillings of disputes that are out there today that will end up in courts one way or the other. Now, and if people's confidence and if people's ability to get those things resolved quickly doesn't work well, then there's going to be a problem. And so as part of this exercise, the journey that we started with the judiciary in 2014, working with different people, have been really remarkable. Whether it is the launch of the alternative dispute resolution, where I understand we have now covered more than 20 billion shillings worth of cases that have been posted through that, whether it's waivers of court filing fees for commercial disputes that is happening, whether it is introduction of small claims courts, a lot of changes have been happening. And of course, today we are here to witness a really significant milestone in filing electronically for cases. I had the opportunity to visit the registry here in Nairobi, and I don't need to say a lot, but I think it was quite scary. The way things are done, the photocopying and the cost. And so what we're going to witness today, I think, has been really, really remarkable. And I just want to end by saying that this would not have happened without the dedication right from the top, and of course a lot of troops that have really taken their time to make these things work. Of course, Justice Fred Ocheng was mentioned. He's one of the first people I've started working with. Elizabeth Tenui, of course, and now Mary Kasango, who is now taking over running with this, and many others that I don't get time to see. But the one person who, whenever I have, got out to reach out to make things work and, drive this forward, is the Chief Justice himself through his office. Of course, the likes of Conrad and others who, whether it is a Saturday or a Sunday, the Chief Justice have been available to deal with some of these issues. So I just want to thank all those people and many others who I'm sure have facilitated this thing to get to where it is. It's been a remarkable thing. The perception of competitiveness within our judiciary today, even though it's looked at through a very narrow lens, and the narrow lens is, if there is a commercial dispute involving $5,000 of a small business, how long does it take for this person to get his case resolved? That is a question that is put across all countries in the world, the 190 countries. Rightly or wrongly, today, the feeling of the stakeholders in this country is that to get a resolution of a 5,000 shilling commercial dispute in Kenya takes 465 days. We think that is a bit of an overstatement, but it is what the private sector, the respondents, feel they do. Not to mention the fees and this and that, whether it is the legal fees, the filing fees, and so on and so forth. I think with the coming now into place of the small claims court, from the 465, we will be talking in terms of weeks. And I really can't wait for the small claims court to be alive and kicking. All I will say is it requires a lot of heavy lifting. There's been a lot of constraints. I want to really sincerely thank the Chief Justice for all the commitment and the effort for these things to work. And today, I want to say congratulations, and we look forward to more reforms in the future. Thank you very much, ladies and gentlemen.
Thank you, CS, for sharing that information. I want to assure you that the judiciary will continue with efforts towards efficiency, and we believe that this, alongside other initiatives, will create justice outcomes that will make Kenya an attractive destination for business. Thank you very much for joining us and for those remarks. I would now like to ask His Excellency Franz McCann, Kenya's ambassador, that's ambassador of the Kingdom of the Netherlands to Kenya, to come and address us. Ambassador McCann, please.
Thank you very much. I had not prepared to speak, but I should have known, actually. But Honorable Chief Justice, Deputy Chief Justice CS Aid Mohammed, DPP, is really a proud man standing in front of you because we have been able to contribute to the success that is being celebrated today. Our journey has also been a long one. I'm almost finishing 5 years of service here in Kenya. I'm basically on my way out and just, let's say, on the doorstep. To be able to witness this celebration is really a present. I recall when starting out, also with IDLO, in the commercial court with Justice Fred Ocheng. I don't know, is he here? He was. And then Willy Mutunga. And then, of course, leadership has been taken over by Chief Justice Maraga. It is a very important step because it was staggering. Of course, the backlogs that we saw, the length of all the court cases, and really, as CS Aid Mohammed said, a disincentive to many companies and investors. And I have actually witnessed cases in which new investors, new traders coming into Kenya were confronted with injunctions and called it a day and moved out again. As justice, as a judiciary and a justice system, you don't know how important it is to be transparent and to have a clear idea that there is a fair trial, that it's quick. There's also now mediation, there are small courts, small cases courts. These are all very, very reassuring elements of the justice sector for Kenya also to move up on that doing business ladder of the World Bank, to which, by the way, also the Netherlands has contributed several years through the IFC of World Bank. So it's an important step. It's also nice to see, as was alluded to already, that when you're in crisis, like now with COVID, that modernization and a leapfrog issue like digitization is really helping to carry on with the work, which was not possible before. Then everybody can see the benefits of this system. And I'm really heartened by all the speakers we've had so far, that they basically pledged their cooperation and their support to the whole digitization, because it is the way also to make this quick step up in, let's say, doing justice, but also in doing business, which basically also post-COVID will be the biggest challenge to get Kenya back on its feet once we're going back to a kind of a normal. It's also my opportunity, let's say last opportunity probably, Justice, Chief Justice, to thank you for your leadership, for the way you have really led this process in a very good way, so as to be able to celebrate in Corona times this success. I wish you also all the success for the rest of your life, I should say, because I don't know what you will be doing next, but I'm sure that everybody will remember you for the legacy that we are celebrating today. Thank you very much. Thank you, sir.
Thank you, Your Excellency. We appreciate all the support we have received from the embassy, not just for this, but other strategic areas as well. And as you leave, we hope that we will get another opportunity to interact at a different level in different capacities. God bless you. It's now my pleasure to ask a representative of the Judicial Service Commission, Professor Olive Mugenda, to speak to us. Professor, please.
the Honorable Chief Justice, the Honorable Deputy Chief Justice, Honorable Principal Judges of the High Court and of the Courts of the Equal Status, presiding judges, judges of various courts, Honorable Magistrates, CS Adan Mohammed, PS Ocheng, the Ambassador, Federal Commissioners, the Chief Registrar, all judicial officers, judicial staff, and invited guests. I speak on behalf of the Commission, the Judicial Service Commission. Some of the commissioners are not here, but some are here, and I would like them to just maybe put their hand up so that we can recognize them. And, but we just mentioned their names. Of course, I'll start with our chair, who is a CJ in the back, and also Honorable Justice Philomena Muiru behind here. I would like to also recognize the Court of Appeal Judge, Commissioner Judge Wasame, right there. Commissioner Emery Omide, who is also Chief Magistrate, Makadara Courts. Honorable Commissioner, Judge of the High Court, Judge Majaja. Honorable Commissioner representing LSK, Honorable Macharia Jero. Thank you very much. So we are very, very happy about the achievement of this key milestone as a commission. It's a target we have been pursuing for a long time, and we are happy that we have achieved this, particularly at this critical time. I think, as it has been said before, the COVID-19 pandemic, with all the miseries it has brought, has been a catalyst in achieving this important milestone, given that we have had to find a way of undertaking our court business without physically dealing with files, since we are going to be filing them electronically. So I'm saying the pandemic has been a catalyst because we started, I think as President of RSK said, we started thinking about digitizing our filing system many years ago, but with the danger of the disease, this has been, it has been fast-tracked. So we are excited as JSC. I'll just briefly outline a few key advantages we see as a commission, and some of them have been mentioned, so I'll risk a bit of repeating just for emphasis. And one of the key benefit that we see is that this will enable fast filing and retrieval of the cases, especially at this time of this pandemic. It will also enable agile dissemination of records and documents, sharing of digital files between the various agencies, as has been said before, between the DPP and also ESC and other agencies. There will also be better record management, including disposal, and also off-site or remote access. There will be no need to be in the same building or have the file carried physically. And when it is rolled out to other places, outside Nairobi, it means that a case can be had, for example, in Rodwa without requiring physical files from Nairobi. So we are looking forward to this. And also, there will be better disaster recovery and business continuity with off-site backup of digital files in future. Once we expand from outside Nairobi, it means there will be reduced risk of loss of files to registry destruction. We know cases where if people don't want evidence, registers have been banned, and this now will make sure that we have backup of these digital files once given this process. There will also be reduced space requirements and increased storage capacity. As we know, of course, with ICT, the storage capacity is not an issue. You can store as many files as you want. Right now, as we design even our court premises, we have to make sure that we have enough space for storage. This will not be necessary anymore as we go on. So there'll be that reduced space requirement with this process that we're starting today. There's also the increased staff and systems productivity. There'll be no time wasted running through bundles of files in future and rows of shelves. I hope that with this then our staff can do more productive work, not just looking for files and which take forever. So we are really looking for our staff then to be able to do other productive work than they are doing now, dealing with the files. In addition to this, with electronic document management system, tracking of access, reading, writing, modifying, and deleting, while maintaining audit trail and system logs. I'm really very excited about this because, again, in future, people who have been trying to modify some of these filings, either by removing papers or trying to add some writings or to delete, all that will not be possible because there will be audit trail and system logs, which means if you try to delete something or to add something, we'll be able to know who is doing that. So I think this eventually will enhance integrity and also security of the digital files. So it's a major milestone that a lot of Kenyans have been complaining about, files lost or changed or documents removed. All that will be a thing of the past, and we are excited about this. Lastly, access rights in future also can be granted on the basis of roles and responsibilities, which is digitally enforced. And this will also enhance controls and assurances. I look forward for a time when access can be given to people depending on their responsibility, so that some of the clerks are given responsibility up to their level. Maybe the judges and magistrates can be given access up to their level, so that they'll be more accountable, so that a clerk, if you are not allowed to access certain files, you'll not be able to access those files. And that way now, will be more accountable. With the electronic document management system, again, and increased internet connectivity, there will be opportunity to serve our citizens better. And, as we have said before, this will really help us do what we're supposed to do, more efficiently. But lastly, for the staff, I know sometimes staff members, when there is improvement, especially ICT, they get worried that maybe they might lose their jobs. What will happen? If you are not, are we going to be needed anymore? And for me, on behalf of the Commission, is to just assure them that this does not affect their jobs. All they need to do is to make sure that they enhance their skills in knowledge management, data analysis, information science, and all that, and so that they can do their work better. So there's no danger of saying, oh, now ICT is going to make us lose our jobs. That will not happen. As I said, even us as Commission and as Judiciary, we are going to make sure that they get the relevant training so that they can do this efficiently and of course, still secure their jobs. So I would like to just, on behalf of the JSC, thank again all those who have been working behind the scenes, working very hard, all the committees. We want to thank you for this milestone, and also thank the CJ for providing the overall leadership. Thank you very much. It's now my pleasure and honor to invite Honorable DCJ Philomena Mwiru to come and address us. Thank you.
The Honorable the Chief Justice and President of the Supreme Court of Kenya, the Honorable Mr. David Kenani Maraga, my colleagues, the Honorable Judges of all Superior Courts, my colleagues at the Judicial Service Commission, fellow commissioners present, the Honorable the Chief Registrar of the Judiciary, the honorable judicial officers here present, the judiciary staff, the honorable the DPP Nudin Aji, the Honorable Mubarak from ESCC, our development partners, invited guests, ladies and gentlemen. It is still good morning, just a few minutes to leave that part of the day behind us, and therefore good morning to all of us. I am delighted to join us today as we officially launch the electronic filing of cases at the Nairobi courts. It is an important milestone for the institution and key components in the judiciary digital strategy as contained in the Honorable the Chief Justice's strategy, the document. The principle sustaining judiciary transformation, the SJT, a service delivery agenda for the period 2017-2021. Ladies and gentlemen, today's milestone is not a singular event. It's rather the culmination of years of commitment and hard work. Successive judiciary strategic plans from 2005 to date have recognized the need to adopt and institutionalize ICT, especially in the automation of court processes. Under the Judiciary Transformation Framework 2012-2016, harnessing technology as an enabler for justice was one of our 4 pillars, recognizing ICT enormous potential to improve the administration of justice. Building on these policy prescriptions and the activities undertaken thereunder, the SJT that was launched by the Honorable the Chief Justice in January 2017 also placed ICT at the center of our institution's service delivery agenda. The SJT outlined a comprehensive judiciary digital strategy under which e-filing is a very key component in increasing the speed and the quality of justice, as well as in the Honorable the Chief Justice's blueprint to join and strengthen case backlog reduction strategy. Ladies and gentlemen, the launch today of e-filing at the Nairobi courts is indeed a laudable milestone. However, we shall be judged not by how illustriously we began, but by how successfully we finish. Not on the content of our aspirations, but on the tangible benefits experienced by our clients and court users. Only through proper implementation and utilization will we succeed in the e-filing platform and thereby enhance serious efficiency and efficacy in the process of accessing justice. ICT generally and e-filing in particular merely provide us with the tools necessary to achieve our objectives. These tools still depend on a large extent on the competence and rectitude of those that utilize them. Under the SJT, work methods and individual accountability are emphasized with a focus on increasing productivity, efficiency, and effectiveness. Whilst e-filing platform we launched today provides an important tool, it is the judges, the judicial officers, and the judiciary staff who operationalize and implement it that will be the bellwether of its success. All of us are in this together. We are all cogs in one big wheel. Whilst our clerical staff must be our customer care support mechanism, the rest of us must do our part. Further, the cooperation and indulgence of our partners in the justice system will be critical to the immediate success of the e-filing platform. Cognizant that improved service delivery of all those that come seeking justice through our courts is our primary collective objective, I urge us to increase and deepen our collaboration and mutual support during the operationalization of the e-filing platform. Through bona fides engagement, constructive feedback, thank you Nelson Harvey, President LSK, robust backbench and CUC discussions, we must ensure the success of the e-filing system. Its effective rollout across the country and enhance the implementation of our court automation initiatives within the judiciary. Ladies and gentlemen, I thank all those that were involved in making today's milestone a reality for your support for the Honorable the Chief Justice's ambitious ICT agenda under the SJT, and your continued commitment to realizing the Honorable the Chief Justice's vision for an agile, dynamic, modern, innovative, accountable, and efficient institution focused on improving service delivery to court users and to the Kenyan people. I must here single out the ICT front runners in our institution for a very big commendation and with gratitude. Please stay the course. Assist the rest to move with us. Those still minded to slow us down, resist this process, or hoping to take us back to whatever colors, to take us back by whatever colors of maneuvers, please style up and move with the times. We are already very late, as it were. I thank our partners here present, including our development partners, for continued cooperation and support. In particular, I would like to thank very specially the Judiciary Integrated Court Management System Committee, ably chaired by the Honorable Steve Gatembo Kairu, Judge of the Court of Appeal. Thank you, Judge. Eckling, this is one of those rare times that you get a lot of praise from me. Well done, Steve Eckling. You and I know what the Chief Justice has taken us through the last few months. He didn't call a meeting on Saturday, but he called us to meetings on Sundays. He called us to meetings very early in the morning. We would start at 6. He called us to meetings in the evenings. Well done, and thank you for bearing with the Chief Justice. I've worked with him since 2011. I never saw more passion than during this ICT time. I urge us to double our efforts and commitments towards the realization of the objectives in the judiciary digital strategy. But my people at the judiciary, we have just begun. We can no longer go back to being analog. We must continue and seriously institutionalize this digital era. We must. We don't have a choice in the matter. We do not have a choice in the matter. And some of us here present know what I'm talking about. We shall resist any attempts to take us to the analog days. Thank you very much for listening to me. Please pray for us as we undertake this. Pray that we never lose the money to carry on. Pray that we shall be of good health. Pray that nothing will take us back. And pray that from Nairobi, it is to the entire country. It's my pleasure, the Honorable the Chief Justice, it's my privilege and my duty to now call upon you, Honorable Chief Justice David Kenani Maraga, to please come and launch your baby. David Maraga.
Thank you very much, ladies and gentlemen. Please sit down. I requested this gentleman to sanitize the microphone a little better because quite a number of you have talked about my age. And you know what that means. And I want to thank those who have wished me well. When the LSK president was talking, it's like he was bidding me farewell. I'm still around for a while. We have quite a number of things to do. As you know, the judiciary has a very, very strict protocol. A retiring judge takes terminal leave. So when my time comes, I will receive a letter from the CRJ asking me to take terminal leave. I believe that will be somewhere in November. So I'm still around. Don't worry. I'm still around, and we are going to meet in a number of functions. The Honorable, the Deputy Chief Justice, Justice Philomena Mwilu, the judges of the Supreme Court here present, the President of the Court of Appeal, and the judges of the Superior Court here present, the commissioners of the Judicial Service Commission, Mr. Aden Mohamed, the CS, East African Affairs, Mr. Uching, representing Mr. Mucheru, the Minister, the CS ICT, Your Excellency, Franz McCann, the Netherlands Ambassador to Kenya, the Chief Registrar of the Judiciary, the Director of Public Prosecutions, Mr. Nudin Haji, the CEO of ESCC, Mr. Mubarak, the President of the Law Society of Kenya, all heads of the agencies of the NCAJ represented here, all protocols observed, ladies and gentlemen, good afternoon. Today is a great day for the judiciary and the administration of justice in general. It marks the singular most important step in our long journey to harnessing information technology as an integral part of our service delivery to our people. It's exactly 10 years ago when the digitization of the court records was identified as a critical aspect of the judicial reforms by the task force then headed by the Honorable Justice William Ouko, the present Court of Appeal President, in 2010. This is what the East Task Force said then, and I quote, "An ICT policy and a master plan should be operationalized in the judiciary to ensure strategic development of ICT infrastructure and systems for present and future needs." He further observed that judicial reforms must always focus on information and communication management in the institution, and that resources should be provided to the judiciary to facilitate digitization of the court records, automation of the court proceedings, and the establishment of interactive databases, end of quote. Subsequently, there have been many reports and many efforts to mainstream ICT as an integral feature in the judiciary's day-to-day work. For example, the Judiciary Information Communication Technology Committee, chaired by the retired Justice Philip Waki, even as far back as 2011, was spearheading many infrastructural and other initiatives aimed at mainstreaming technology in the judiciary. Along the way, countless pilot projects have been undertaken, most of them at the Milimani Law Courts, but the rollout of the extensive digitization has remained elusive, with one challenge being consistent over the years: lack of funds to move beyond the pilot stage. Some of these pilot projects have proven to be highly successful. The implementation of the e-filing system at the Milimani Law Courts, undertaken in close collaboration with Mr. Aden Mohamed, then CS for industrialization, and he holds that fort up to now, I believe, has, for instance, directly contributed to the improvement of Kenya's ease of doing business. I want to make a remark here that we want to do our very best. We are doing and we want to continue doing our very best, Mr. Aden, to have our country rank high in the ease of business, of doing business, so that we can attract investment. You have emphasized that. You have talked about the time it takes to finalize cases. And the figure, I mean, the number of 465 days are there in our records, and you have mentioned that. When in other jurisdictions, less than 200 days are taken in finalizing dispute resolutions so that investors can be attracted. This requires not only cooperation, but resources. And I'm sure that you will take the message that you have talked to the relevant authorities to ensure that we have resources so that we can go on. While most of these projects are yet to have a judiciary-wide impact, they have reaffirmed our institutional capacity to adapt to technology and to manage it for the benefit of our stakeholders. Indeed, it is from the experiences and the lessons learned in the pilots that we have reached where we are today. It has also been through the effort of the entire judiciary juggernaut, driven by the desire to succeed, that has enabled us to come this far. Ladies and gentlemen, from the onset, increased use of ICT has been identified as a key plank in our efforts to transform the judiciary into a modern, progressive institution that is succinctly responsive to the needs of the people we serve. The Judiciary Transformation Framework, launched in 2012 by the retired Justice Willie Mutunga, and my own blueprint, Sustaining Judiciary Transformation, were very clear on this. When I launched the SJT in January 2017, we shifted from the institutional building and the capacity development agenda that defined JTF and focused on a service delivery agenda. SJT emphasizes the improvement in the speed and the quality of service delivery in the judiciary by increasing efficiency and effectiveness at the individual and system levels. One of our primary initiatives was the design and adoption of a digital strategy that sought to boost not only judicial operations, but also enterprise resource planning capabilities in order to assist in our administration functions. Central to this was the establishment of an ICT infrastructure that would support these initiatives, including provision of internet access to all our courts, as well as enhancement of our security and disaster recovery capabilities. As we speak, all our courts except Mbarambala and Kakuma law courts, which are in the far-flung areas, are all connected to reliable internet. These efforts are anchored on the Judiciary ICT Master Plan 2018-2022, an ambitious blueprint that, once fully implemented, will see the judiciary reap the full benefits of technology and dramatically improve our ability to deliver a service efficiently and effectively, as well as equitably. Equity is an important variable here. No matter how efficient and effective we become, it will do little good to the people of Kenya if, by having excellent ICT assets, such as what we are inaugurating today, it results in only a few privileged people being able to make use of it. If what we are launching today locks out sections of the community, or is discriminatory and shows partiality to a class of litigants, we will have failed. Conscious of this, we have taken care to ensure that everyone is well served by all the technological initiatives we adopt. I'll revert to that a little later. Ladies and gentlemen, the electronic filing system we are launching today has been under development for the last 3 years. It is a robust system that will fundamentally change the way judicial officers and judicial staff work, as well as the way court users interface with the courts. Even though case filing is the core function of the system, it represents a transformation that touches on almost all courtroom activities. I have heard some people ask whether, upon filing their documents online, they will be printed and put in physical files for use when they come to court. The answer to that is an emphatic no. The digitization is total, meaning that in the courtroom, all parties will access case materials online. Even when hearings are going on, all parties will have access to the documents online. Some people said they can always have their own physical files. That's fine. That's fine, Mr. Harvey, with your team. And I don't think that is going to be the case. Or any other parties. If they want to have their physical files, that's fine. But for us in the system, for the judges and the magistrates and everybody in the judiciary, we will only have electronic files. This means that the operation of the court registries, as we know it today, will drastically change. Court documents previously stored and retrieved in physical files will henceforth be stored and retrieved in soft form from the digital registry. This system, which I'm proud to say has been designed, developed, and implemented by our own Judiciary Directorate of ICT, has many advantages and is expected to significantly impact on the speed, accuracy, and efficiency of service delivery. One of the significant advantages of digitization is the assurance of the integrity of court files. Those who have been in the judiciary or in the legal system for a while will tell you that we have had serious challenges of even some some documents, not even by any malicious act, just getting misplaced from the file. Some of them happen to be even exhibits, which, if parties had not kept any records, it becomes extremely difficult to end a matter. So with that, and even some proceedings or court records not having all the documents, as a result, we have had quite a number of challenges. But with the digitization, that problem will be overcome, and we'll be able to move on. You have also, and I'm sure quite a number of practitioners here and even the litigants know the challenges we have had and the frustrations we have had with the misplacement and loss of files. Let me confess here that sometimes the files don't get lost. Malicious acts of some of our staff in collusion with the outsiders, those who perhaps don't want their cases to go on, or for one reason or the other, don't want a file to come before the judge, just take a file from its bundle and puts it in a wrong bundle. And it takes a long time, and sometimes even after some time, that same fellow pulls that file and says, oh, the file we have been looking for is here. That is something we are going to go over, and it will be a thing of the past. And I think that is a significant advantage. The other challenge stakeholders in the justice sector have faced is the authentication of court orders. We have occasionally had situations where orders have been issued for the release of accused persons or those who in remand in prison. And quite genuinely, the prison authorities look at some of the documents, depending especially on the typeset, and wonder whether or not they are genuine. And it takes quite a while. You find that sometimes somebody has been released, and it takes about 2-3 days for him to be set free from prison, because the prison authorities wanted to make sure that the order they are acting on is authentic. The system we are launching today will seamlessly integrate with all major stakeholders, such as the Office of the Director of Public Prosecutions, the Prisons Department, and the Probation. And I've asked my ICT people to find a way of how we can integrate with the Lands Office, because the title deeds that we are given as security for bond or bail, we want to be sure that they are authentic, because we have run into problems with some of them which are not authentic. So we will have we want to find a way of integrating with the Ministry of Lands and be able to sort out that problem. I'm happy to note that the ODPP have done their best, and you will see from the demonstration they will show us here, they will be the first stakeholder to integrate with our system. And from the comfort of your office, Mr. DPP, and your people, you will be able to file the charge sheets and other documents, and you don't know how much that will save the public in terms of time and the anxiety of having to wait for a very, very long time. If I say here that there are cases, there are times when we have come to court, you get magistrates waiting for the accused persons are in court cells, but the file has not come from the office of the ODPP. And it takes several hours before such a matter is dealt with. With that integration, that will also be a thing of the past. The system has many other facets to it. In addition to the cases being registered in the system, it has an automated fee assessment and payment module, which utilizes various platforms such as M-Pesa and credit cards to effect the required financial transactions and generate e-receipts. This will minimize the pilferage of court fees and help us to work efficiently. I want to mention here that we are in the final stages of coming out with an integrated fee schedule that will be input in the system in a few days, but that is not going to cause any challenge whatsoever. We have made arrangements of how the court fees will be assessed, and after we integrate that, parties and particularly lawyers, you can file your documents even over the weekend from the comfort of your office, pay fees electronically, and get a case number while you are seated there during the weekend. Other important features include the indexed retrieval and viewing model for judges and magistrates to access documents, the ability to search for cases, and an integrated court calendar. Many litigants, including our brothers and sisters in the diaspora, never get to know what transpires in the hearing of their cases. Since court records are public documents, we will in future make it possible for the public, upon payment of the requisite minimal fees, be allowed or be given access to peruse the court file online. Ladies and gentlemen, As you know, time is among the court's most valuable resources. Our digitization efforts, therefore, must not only merely pander to the prestige of achieving global standards in use of technology, exciting though that is, but also ensure that it adds in improving our efficiency, leading to quicker resolution of the disputes before us. An integral companion of e-filing is the case tracking system, which has been mentioned, which we have already introduced in 60 court stations across the country. The remaining 72 stations will be using the system by end of October this year. The court tracking system involves the monitoring and the managing of cases in the court docket from the time the case is filed to the moment it is finally disposed by either trial, settlement, or otherwise. When optimally used, it ensures that all cases progress swiftly without unnecessary delay, and feedback is given to the judiciary leadership when challenges occur in any of our courts. An integral part of the case tracking system is a messaging service that allows us to send updates to our clients through SMS. The clients can themselves prompt the updates by sending SMS with the case tracking number to the short code number 22490. So you can see we are going to offer services. Even litigants who want to know the status of their case. All they need is to send an SMS, and it will be responded to, and they will be told what is happening, instead of having to travel long distances to come and peruse the court file to know the position. Besides the case tracking system, the judiciary is also implementing a digital court recording and transcription system in 32 courtrooms around the country. 6 courtrooms in the commercial division of the High Court at Milimani are already operational, while installation is currently being done in another 26 courts, including the Anti-Corruption Court in Nairobi. The full implementation of this system will bring an end to the manual recording of court proceedings. The audio recorded proceedings will thereafter be passed on to transcribers who, through strict and elaborate procedures, will prepare the official court records in text form. The judiciary has partnered with the Ministry of ICT through the Achira project, which will engage quite a number of our youths in doing the transcription, thereby providing employment to thousands of our young people. Mr. Cheng, I want you to express our sincere gratitude to the CS, Mr. Mucheru. He spoke to me this morning, and he tendered his apologies that he was not able to come, for the support we have received from the ministry. We want to continue that partnership, and we trust that it is going to assist us a great deal. We have a lot of work still to be done, so we need your assistance. ICT has enormous potential to improve the administration of justice. Indeed, we have seen it come in handy in the enabling justice delivery in the face of the COVID-19 crisis. We have, since the onset of the pandemic, established virtual courts and engaged litigants through online meeting applications. Hundreds of cases have been heard successfully, despite open court activities being significantly reduced in the wake of the pandemic. You have already heard about how we have had quite a number of applications and appeals online. I have received messages from quite a number of your members, Mr. Harvey, who are very happy that they can be able, to argue cases And don't waste any time at all. We know our city. It takes almost 45 minutes for one to drive from Westlands to come to court. Then he waits in court for the court to get to his case. And then once the matter is finalized, which takes about 30 minutes, he has to drive for another 45 minutes to 1 hour back to his office. All that will be time saved, and I have received quite encouraging messages from litigants and lawyers, and we want to all work together and be able to help, to expedite service delivery. The coronavirus pandemic has in a way become a blessing in disguise. Among the many long-term implications of our increased use of technology is that moving forward, we will no longer require expert witnesses such as the government chemists, pathologists, ballistic experts, and the handwriting experts to appear in court in person. Quite a number of my colleagues here, the trial judges, know how many times we adjourn cases because these witnesses are not able to come. We have a handful, is it 2 or 3 handwriting experts in the country? Ballistic experts are, I don't know, they can't be more than 5. And you find that the cases are adjourned several times, not because these witnesses don't want to come to court, but because they are engaged in other places. A witness, if the same witness is testifying in Mombasa, he needs 2-3 days to travel there, to have, then he is heard, and their evidence normally takes hardly 15 minutes before they come back. I have given firm instructions that going forward, these witnesses will not be summoned anymore. Even if we are having a physical checking of evidence in court, those particular witnesses, we will have to take their evidence online so that we save time. It will be a pleasure, I'm sure, to our doctors to be told that, look, give us 15 minutes of your time. From the comfort of your clinic, just be there at 10 and testify, and we will be done. These are great advances, and I'm very happy and excited about them. These advances are carefully guided by a robust judiciary ICT policy, whose overall objective is to provide a governance framework for the acquisition, use, and disposal of ICT in the judiciary. Key objectives of the policy include ensuring that the security of our data and the information is guaranteed. Indeed, even as we launch this initiative today, one of the most recurrent questions is whether the integrity of the materials filed and stored electronically will be maintained at all times. This has featured, you will recall, Mr. Harvey, and your team, especially the chair, the Nairobi chapter of the Nairobi branch of the Law Society. We have had meetings on this, and you have actually raised this issue because it's a great, an issue of great concern. I want to assure you that the integrity of the court record will be ensured. Besides the routine security protocols like redundant systems, strong access controls, and encryption, we have implemented specific security measures that reflect global best practices in the data security. Of course, it will be fully hardy for me to enumerate those measures here for obvious reasons, but rest assured that security has been taken care of, and we will have no problem at all. We cannot expect an undertaking of this magnitude to be implemented without any hiccups, either in the performance of the technology or the ability of the people to use it properly. Besides, it is consistent with human nature to be apprehensive about change, sometimes even to the extent of resisting it, only to embrace it later enthusiastically and continue. You know, this plan of technology has been around. When it started, quite a number of us judges, especially the old fogies, had a few problems. I remember one of my colleagues, whom I will not mention, you ask him for his email address and he tells you it is confidential. Of course, he passes the message very clearly that he doesn't know what you're talking about. So there is that that fear of the unknown and not appearing. And you know, judges and lawyers, we are known as learned people. So to be seen to be ignorant in some of these issues, you don't want to show to the rest of the public that you are ignorant in this. But I want to say this. Let us not be bothered about that. We were not trained as ICT professionals. We are trained as lawyers. The ICT people, Mr. Chiang here, if you ask him a few questions on law, he will be at sea. So why should we be worried if you just say, look, I don't know how to do this, I want assistance. Let us get that out of us and be able to move on. What I would like to assure you today, ladies and gentlemen, is that we shall strive to address all challenges that emerge as we implement the system, and to assist all our stakeholders to adapt to the new requirements as soon as possible and smoothly move on. Towards this end, we have undertaken extensive training, not only for the judiciary staff, but also external stakeholders. As I said earlier, this system will not serve the highest ideals of just delivery if it is only convenient to a section of the court users. We have therefore initiated various programs aimed at ensuring that ordinary wananchi seeking court services, especially those who may not be familiar with the ICT infrastructure and the court procedures, to be assisted in our court stations. This includes the establishment of the ICT support centers within our stations, where court users, especially the severely indigent, who may not afford the fees charged at the cyber cafes, to come to court and be assisted. On the other hand, cyber cafes which meet our stringent standards will be accredited and their staff trained so that they may assist court users who do not have ICT facilities in their places of work. In further pursuit of inclusivity, we plan to quickly roll out this service to other parts of the country, beginning with Mombasa and Kisumu. As you know, we have a real problem in Mombasa because quite a number of our staff tested positive to the pandemic. As a result, the court operations in Mombasa have literally ground to a halt. I was speaking with the lawyers from Mombasa and the presiding judge of the Mombasa station. They are saying, look, in Nairobi you can operate. Please, why don't you even start that e-filing system in Mombasa? But I told him that, look, the way we have planned things, the way we have, the ICT people have done it, it is not possible to do it immediately. But that is one other thing, Mr. Ickling, you are going to have to do. Move very fast and get Mombasa connected so that they are able to move on. And then we will move on to the other parts. This will start as soon as we have sufficient storage capacity for the heavy data generated in the new system. To this end, we are at an advanced stage in procuring necessary servers and storage capacity to ensure that we achieve this objective as soon as possible. But in any case, not later than 3 months from now. I want to say here that the CRJ has shown me the budget we have for this financial year. We have already started, and one of the major programs we have is the establishment of the data center. The establishment of the data center, buying the servers so that we can assure everybody that we have enough storage. I trust that the amount we have been given will not be slashed, because if it is, we will grind to a halt. To ensure that the increased use of ICT is fully anchored in law, we have undertaken various initiatives aimed at aligning the new processes to relevant legislations. We have finalized the development of the practice direction, revised the rules, and proposed amendment to the Civil Procedure Act and the Evidence Act, as well as the Criminal Procedure Act, to align the ICT environment and facilitate the widespread adoption of technology. In this regard, we are doing all our very best, and I'm happy to see Justice Musinga here, the chair of the Rules Committee. We are there, and there will be no problem at all. The proposed changes are already being reviewed by our stakeholders, including the Law Society and the general public, and we expect to receive a feedback as soon so that we can be able to complete the process. The code digitization journey has, since the onset, benefited from generous funding from many of our supporters, and I wish to sincerely thank all of them. I would like to single out the International Development Law Organization for their support and the e-filing initiative from the start, as well as the United Nations Office on Drug and Crime, GIZ, the World Bank, through Judicial Performance Improvement Project, and the Government of Kenya for the support we have received so far. In this regard, I want once again to sincerely thank His Excellency Ambassador Francis McCain. I requested that he be given a minute to say something because of the contribution he has made to this project. He has availed the funds, and we are very, very grateful. As you go back, Your Excellency, please go with our gratitude that the people of Kenya appreciate the support we have received from your country. I have already talked about the Ministry of ICT, the support they have given us, and we trust that they will continue to support us. They have undertaken that, and I have no doubt whatsoever, and they will assist us, and we will move on. JSC has been wonderful. The support you have given us, the JSC members, we are grateful, and we will continue to be grateful. I want to single out one or two other people who have worked very, very hard. Justice Gatembu Cairo, the chair of the Integrated Court Management System Committee, and the entire membership of the committee, and his predecessor, Justice Mwongo. Did I see him here? He may not be here. As well as Justice Souko and Waki, who have already mentioned in the work they have done in the past to assist in this process. The ICT Directorate, led by the Acting Director, Mr. Stephen Eckling, and many other stakeholders who have worked and continue to work hard for the good work they have done. DCJ was telling you that I have pushed them very hard, especially in the last 1 month. I want to sincerely thank you, Eckling, and your team, Karanja and the others, where are you? Please stand up once again. I want to thank you most sincerely for the good work you have done. You know, as you have heard, I'm getting old, so my day starts at about 4 o'clock in the morning. Sometimes I push these people by 8 o'clock if they are not able to connect and we have a meeting. I can't understand how they can be late at 8 o'clock when I've been up for almost 6 hours. So thank you very much for the good work you have done, and bear with me for the push I have had to throw your way, but you have taken it with stride, and I'm very, very grateful. As Charles Katembu said, the LSK, ODPP, and the prison department, as well as the probation and all other stakeholders, have been very, very supportive and have supported us. I want to mention here that Mr. Harvey, the president, I received yesterday a letter from the chair of the branch chairs, a message of goodwill and saying that they are going to support us and we move on. And I'm very, very, very grateful. What I want to say, Mr. Harvey, and with all humility and understanding, the problem we have now, especially with the virtual courts, is because of poor connectivity, internet connectivity. You find one litigant at one end of the country with poor internet connectivity is unable to be heard. Or when he starts, he's breaking and the proceedings can't go on. That's why, as you said, you take so many minutes asking, my Lord, can you hear me? My Lord, can you see me? It is not entirely the problem with the court system. It may be very well, and I want to say this with humility, not trying to demean anybody. It may be very well the problem with internet connectivity from your offices. Going forward, as we have said, we have no choice, we can't go back. Ask your members to try their best and get stable internet connectivity. And in that regard, Mr. Ching, even when when we are paid, especially in the countryside, admittedly internet connectivity is poor. Let the ministry do something about that so that we can move forward. In this time and age, one of the things we should have as a country is internet connectivity, which is stable, to enable us transact the business we have. We are all connecting to this, and we cannot afford to be left behind as a country. I conclude my speech with the great hope that this system will generate the necessary impetus to fully integrate ICT into all the justice processes. Honorable judges, judicial officers, ladies and gentlemen, with regard to the use of technology, the proverbial hour is here with us. I'm happy to note that we are all gradually embracing these changes, and we are going to move forward. As the DCJ said, we cannot afford to go back. We cannot afford to be left behind. As a matter of fact, as an arm of government, we should have gotten here more than even 10 years before. And I'm sure our members of parliament some of them must be listening to me. What the judiciary requires is some reasonable funds to be able to run its operations. You have heard the minister Mr. Arden, how they are being pushed by the investors to ensure that court processes are fast. Because if the court processes are not going to be fast, no investor will be interested in our country. And many, many other things. So if we don't have enough resources, we will not be able to run this. And as I said, we are here today courtesy of IDLO. If we can't get funding, I'm sorry to tell you, if we can't get funding, this project will fall in another 1 or 2 years. And I'm sure that is not what we want. When I say this, some people think that I have, the media say the CJ cries for this and that. I will continue crying for the Kenyan people. The judiciary budget is hardly even 1% of the entire country's budget. And I was telling the CRJ to tell Treasury that Article 173, which requires that the judiciary budget be deposited in the judiciary fund as soon as the budget is read, because we live in this country and we know that funding may be a challenge at times. And I asked the CRJ to tell the Treasury that, look, you can hold the salaries and remit it to us monthly. But the development funding, like the amounts we need for this kind of project, please give it to us up front so that we are able to plan. If I may tell you, in November last year, we were at the final stages of completing procurement for servers that we so badly need. Just before we issued the tenders, we approved the tenders, we had a budget cut. And surprisingly for me, the budget cut, which was supposed to be 30% across the board, the vote for ICT was 100%. So what that meant is that we were thrown back into total disarray. We could not go on. I have said we are here today courtesy of IDLO. If we have no funds, we will not move on. I'm sure the members of parliament are listening to me. The service delivery, the judiciary service delivery is to the people you represent. You don't give us enough resources, the cases will drag on for long periods. Let me end there. Ladies and gentlemen, thank you for listening to me. And I want to thank all of you for finding time to come, especially during this period when quite a number of people are scared, like myself, to get to places where you can easily get infected. But we are doing our very best. And all I want to urge is that let us take this pandemic seriously, especially our people in the countryside. Quite a number of people are, what do they say? EO. And they are walking around comfortably. And we take it lightly. Wait until it knocks in your home. Then you will say, yes, there is a problem here. Let us take this seriously. Let us cooperate with the Ministry of Health and take care of ourselves as we move forward. May God bless you abundantly. Thank you very much for listening to me. I've forgotten this and thank you.
Thank you very much, Your Lordship, the Chief Justice, and thank you to the Chief Registrar of the Judiciary, Honorable Anna Madi, for leading us through the program up to this stage. So, ladies and gentlemen, if you look at your programs, we have reached the session where we are going to have a demo of the e-filing system, the system that has brought us here today and the launch. So we thought it's good that we have a preview of the steps that are actually involved in accessing this system. And as it was mentioned earlier, we are going to do it in two stages. We have the Judiciary ICT team led by our acting director of the ICT, Mr. Stephen Ikileng. He will take some minutes demonstrating how to access the system, to file, to pay, and get a case number from the system. And as was mentioned by the Director of Public Prosecutions and alluded to by the Chief Justice, is that we hope that this system will speak with the other agencies in the justice system so that we have a coherent system that serves administration of justice across the sector. And so far, through the efforts of the Office of the Director of Public Prosecutions, we have managed to link the systems from the Director of Public Prosecution. So after Stephen Ikileng, we will have Lillian Obuo from the Office of the Director of Public Prosecutions, also showing a short video on how these two systems have interlinked and actually how they'll be able to file criminal matters from the Office of the Director of Public Prosecution. So I call upon Mr. Steve Ikileng to take us through the filing system. So the screen on my left shortly will display the process. Thank you.
Afternoon. I'll be taking you through the process of e-filing in the system so that we give you an overview of the expectation for our litigants. Shortly, they will be playing that video for you to be able to see exactly the steps that you'll be taken through. The first step in the process is the registration. What you are seeing is that each clients need to register. Just 1 minute. TV screen on the front. Yes. The screens in the front need to. Yeah. Sure. They are supposed to show. Zimezimika. Okay, if we could start it from the beginning. So I'll take you through three parts: registration, filing, and electronic service. So each litigant can access the system through registration, a law firm, organization, or an individual. So for this demonstration, we are going to look at how a law firm can register by providing the business registration number, the law firm name, the email address, and the mobile number. Once you provide those details, you'll be taken through 4 steps. And the second step will be for the purpose of contacts, where you'll give your physical location and even an alternative mobile number. You will also be required to give your username so that we are able to uniquely identify you in the system. You'll provide your password and confirm. And lastly, you'll be required to confirm all your details, that you have correctly captured it. Then you proceed and submit the registration. So all your details you'll confirm at this page, and you submit, and you'll get a notification to activate your account. So that is the first process of getting an account in the system, which you'll be using for filing. So once you activate, you will log into the system with the email address you've just provided and a password. At the homepage, you'll see various menus. You can file a new case. You can file additional documents in an existing case. So this will also capture new cases and existing cases. You will select the court station. For now, we have all the Nairobi courts listed. You'll select the respective station in Nairobi, the respective division or case category, the case type that you intend to initiate. Then you will be taken through 5 steps of case registration. So what happens here, you need to add the parties.
You're moving too fast.
Oh, you're moving too fast. Sorry. The first step, we are going to capture all the details of the parties. Either an individual or an organization. So you'll enter the first plaintiff, the name of the organization, the PIN number, postal address, and email address, a mobile number, and organization email address. That is for the first party. And this process, you can repeat as many parties as required for the case. So for the purpose of this, we'll show how to capture one party. And these are the parties that you represent. This is an account for a law firm. So once you save the parties, they'll all be listed in the system. Then you proceed to the second step, where you give a summary of the case. The citation, the value of the case, and the summary of the case of the prayers, which you can copy from the document and paste. In the third step, you'll be asked to add the specific documents that you intend to file. So we have prepared all the list. You will just select the specific document, and the system will be able to give you parameters to fill that define what document is all about. Once you save all the documents, they will be listed, and it will automatically calculate the fees that is required. So at this step, you're actually doing the fee assessment, which will clearly and automatically assess the fees that are required for that particular case. And you can list as many as required in terms of the nature of your case. And you can see the total for this case is continue adding up, currently at 70,075. You can add an annexure, you can add a supporting affidavit, and many other forms of documents. And the amount have already been provided in the system, so it will just automatically calculate. So the final fee here is 70,085. You can now proceed and upload the document for each area you have selected in terms of assessment. So you upload your PDF documents that you will have prepared earlier, so that you just upload in the system and you proceed. Ensure that each category of the fee assessed has a document. Once you upload all the documents, you now preview your case, your submission, before you click on submit. It will ask you to confirm, and you will submit, and you will be presented with an invoice. This is the invoice that you are expected to pay. It will show you the court, the name of the firm, the pay bill number, the account, and the date. And you'll pay key attention to the reference number, which will be a payment reference number that you will use to make payments, either at the bank or at using M-Pesa. So once you confirm all the details are correct, you can, if you have time, if you don't have the money, you can download and go and get money and pay. If you have the money at hand, you can confirm and click on pay. Once you click on pay, you will be able to see the payment options that are available. You can pay via direct M-Pesa, you can pay by KCB and the KCB bank, even by teller or our agents. So all these payment options will continue adding them, for convenience of our clients. So once you make the payment, the system will check and automatically generate a case number, automatically send you a receipt that you're able to download and view. Now that you have a case number, you can see it is E211. You can download your receipt, and you can even go ahead and view the case details. So that is the process of filing. So that is your payment receipt that you can see on the system, and you can actually download it. If you want to continue reviewing the case, you can check all the documents that you have that have been submitted, and you now can start the process of electronic service. So that is the process for filing that we presented today. This is an overview. There are more details that we have for the purpose of getting the entire course for the e-filing for our litigants. Thank you very much.
Thank you. Thank you very much, Ikileng, for that demonstration of how the e-filing system works. And as had been said earlier, we have an extensive process of training on the use of this system that involves not only the judiciary, but all other stakeholders, and I believe some of the trainings are on. So I will quickly urge Lillian to take us through a demo of the integration of the systems from the system in use at the ODPP's office and the e-filing system in the judiciary. Welcome, Lillian. You can come and stand here as they load the next.
Good afternoon, everybody. I'll take you through our processes in terms of our case management. Earlier on, you are told that we've already developed our own case management system. So just like the judiciary, we also have to log in. So we have to log in, and each and every officer has been given a very unique identification number, and also they have to get in through using a password. So our process is basically starts from the time you receive a file from the investigating agency. So you can see now we are receiving a file from one of the investigating agency. And then once the file has been received, then you make all the recording, you capture all the data, from which agency is it coming from, which institution, who has brought it. You try and collect all the information that is required. Then thereafter, we put what is called a QR code. You can see now we put in the QR code. And after putting in the QR code, now we move into the stage of scanning and indexing all the details in the file. So there you go, we've scanned and put in the details. Then we move into the next step, which we call screening. All these files, once received, they'll come into a pool where they're now screened and allocated to different officers. You can see they've been allocated to different offices here. And then once the officers have received the files, then now they review the file and make the most decision a prosecutor can ever make. That is the decision to prosecute. And once that decision has been made, it will now automatically, we will now link it up with the judiciary, and I'll ask them to pause at this stage, because this is now where we are having the integration. So once a prosecutor has reviewed the file and made the decision to charge, we'll come up with a charge sheet, which is now an electronic charge sheet. We'll put in our digital signatures and stamp, and then now feed it into the judiciary e-system. And yesterday, as DPP indicated earlier on, we were able to test. So you see, we were able to test with the Amada case, and from the details you can see it went to the judiciary and it's written there successfully, it was received successfully, and thereafter, because it's a court that gives the numbers, you can see we received a number. So once it's integrated to the judiciary, so we also now have what you're calling our own case management system, whereby you are now able to follow up the proceedings when it comes to what's the status of the file, how many witnesses have testified, and disclosure. So basically that sums it.
All right, so thank you very much, Lillian, for that short presentation, and together with Ikileng for the presentation on the e-filing system and the integration. As was mentioned, we hope that these systems will work coherently, share databases and information in a way that makes the justice chain flow. This is from the criminal justice sector side, and we also have the other side on civil matters, and we hope to improve this and to train all the stakeholders to use this system seamlessly. Thank you very much for that demonstration. So maybe we can move on to the next session, which is the unveiling of the system. For this, we've had the demo. We thought it's good to demonstrate what we are going to launch so that the launch has some bit of the content of what we are launching, except the speeches and all that. And to do this, we have the screen on the right side of the stage. I assure you, the black curtains does not mean that it's doom inside there. It is the system that we are launching today. So in order to move to this session, I request the Chief Justice, the Deputy Chief Justice, and the members on the high table to kindly stand in front of the black curtains. You can access through the other side, and we stand there, yeah. So as soon as the members of the high table have made their way there, we'll do a count of from 5 to 1, and the curtains will automatically open and we'll have launched this system. So to the technical members, we go 5, 4, 3, 2, 1, go. Thank you very much. So, thank you very much. I would now request, as the Chief Justice and the rest of the delegation, we take the photo, we reach the photo session. Here we will not have a photo session outside because of the social distancing and all that. So I'll request that we have a line up in front of the screen, CJ and the members of the delegation. Yes, please socially distance. Yeah, it is. Okay. So thank you very much. I see Zakim. So as we take the photos and conclude this session, you are kindly invited to lunch and refreshments just outside the tent. I'll just explain. We have 2 serving areas and an eating area the other side of the tent.